Hello and welcome to today's presentation, eDiscovery Best Practices for the In-House Counsel. My name is Alex Spear. I'll be the moderator for today's presentation. This presentation is being brought to you by ZyLAB. Before we begin, please note that the slides and audio are pushed to your computer screen and speakers automatically. With that said, it's my pleasure to introduce our speakers for today's presentation. Joining us are Ralph Losey, Partner National eDiscovery Counsel for Jackson Lewis, and Mary Mack, Enterprise Technology Counsel for ZyLAB. Mary, thank you. I'm going to hand things over to you now.
Thank you, Alex. At today's webcast, we're going to talk about the eDiscovery best practices that Ralph Losey has initiated and championed. They're in their, I would say, I don't know, infancy or toddlerhood stage at this point. And we're going to have a very interactive discussion about why it's important to, especially to attorneys and those who serve attorneys, to understand the best practices. We'll talk about specific cases, some of the newer cases around sanctions for both in-house counsel and outside counsel. And just because we are working with our friend Ralph Losey, who is a partner and one of the very few partners and National eDiscovery Counsel at one of the largest law firms in the world. And Ralph, are you the largest employment provider?
It's neck and neck with the competitor whose name I will not name.
There you go. Ralph is one of the leading bloggers, and certainly in terms of word count, Ralph, on eDiscovery, and is very proficient in both technology and the law and the ability to write and speak. And we are very, very grateful to him for agreeing to talk with us about his best practices.
Well, Mary, I'm just happy to be doing another cyber event with you. It's been too long.
Yeah, and we're getting there. We can see each other's pictures up here, so that's nice. That's not quite live cams, but maybe we're grateful for that too. So today, most corporations rely on outside counsel like Ralph, or outside counsel who are not like Ralph, who may not have the skills, the technical skills to handle their eDiscovery. And its current best practice from all the way back to the ZyLAB days, and we're going to talk about some current cases where both inside counsel and outside counsel need to understand eDiscovery. Otherwise, there are some pretty severe sanctions, and then, of course, the ethics concerns now that the ABA has put forth some guidance around attorneys needing to be proficient to a certain level in technology.
Yeah, Mary, I love this slide here. Bruegel, and those of you watching, I'll give you a moment to try and guess what the Middle Ages office that was in the past. We just skipped over it. But Mary, if you can go back, do you know what kind of office that was from, I don't know, what is that, 1700s, 1600s? Well, if you guess the lawyer's
it's around that time, yes.
Yeah, if you guess the lawyer's office, you are right. And that guy sitting in the back is a scrivener, an actual original scrivener, a person that used to write up all the briefs, etc. And the people hat in hand are the lawyer's client. The lawyer, I think, is wearing a little hat. But anyway, it talks about the point of this is that forever and ever lawyers have been working with paper, but nowadays, as we all know, paper is crazy. There's too much of it. In fact, the reality is it's all gone digital. But when is this, 1995, Mary?
Yeah, 1995, and there's those lovely boxes of paper.
Yeah. Still see that, but when you see that, you know there's about 100 million electronic files that haven't been printed out. The paper is just the tip of the iceberg.
Yeah, and you'll see in law firms and eDiscovery service providers and some corporations, you'll see shelves like that, like that in the boxes now are things like hard drives and thumb drives and various objects that are being preserved.
That's right.
So those of you who are listening to this webcast will understand that the eDiscovery and for our friends across the pond, the eDisclosure best practices are maturing and have been maturing for some time, and so there's less mystery in eDiscovery, especially the. I hear a disagreement.
No, I think you heard a gremlin in the line.
A gremlin in the line. Oh, I thought you were going to talk a little bit about some of the mysteries in eDiscovery. But there are some methodologies that are available for both those in-house and those outside, and the line between inside and outside on the spectrum, towards the left, where there's basically the business functions of information governance and moving into more litigation regulation events like identification of custodians or legal holds or collection and preservation. Those are areas where inside counsel are moving into those areas, and some of them even into early case assessment. And then the other side, which is your the data reduction and the review and production of the evidence for trial, those are traditionally handled by outside counsel, but that line is moving back and forth, and we're going to be talking a little bit about that and how both sides of the house, inside and outside, can use eDiscovery best practices and to undergird their 26G obligations.
Yeah, and I think Mary is referring to, when she was talking left and right, to the old-timey EDRM model, which I taught in law school for many years, actually, in eDiscovery courses. And what I want to present today is a new model that I came up with after a mere 6 years of thinking about this. And this is a model not of the eDiscovery process in total, not a flow of where the information goes in a project, but is really focused in on what lawyers do, both in-house lawyers and outside counsel. What is it that lawyers do? And so after a lot of thought, I came up with a different diagram than the EDRM that doesn't really include vendor activities or non-legal services, but does focus entirely on legal services and is a guide for lawyers. And I did that, number one, because I'm always trying to teach and explain this stuff, and I found it difficult to explain it to lawyers using the EDRM model alone. But number two, and the primary purpose is I wanted to create a skeleton where I could flesh out what the ever-changing best practices are by lawyers. Primarily, this is oriented at lawyers in the United States. What are the lawyers, in-house and outside counsel, doing that is the best way to handle eDiscovery in these 10 steps, 10 functions that lawyers do? And I wanted to make clear, and if you go to the website where this is, it's shown there, edbp.com, that I'm not talking about minimum standards at all. I don't think that is anyone's job except for the courts considering malpractice cases. I do predict that there will be an explosion of malpractice cases in this area over the next 5 to 10 years. We've already seen one or two. But so I'm staying away from minimum standards, but instead I'm talking about what's the best practice, way beyond minimum standards.
And so, Ralph, do you think making the distinction between minimum standard and best practice is a protection against negligence?
No, the protection against negligence is to actually meet the minimum standards. You got to practice. But, yeah, if your eye is on the best practice, on doing what's way above and beyond, the chances of your failing to meet the standards are none. because what I'm talking about is way beyond the minimum standards of what is being practiced by lawyers in a community. Now I'm talking malpractice language. I'm talking about best practice, and that's one of the reasons I recommend that in-house counsel I deal with and other attorneys, that you focus on the best practice. Then you don't have to worry about minimum standards because you're way beyond it.
Very good.
So if you want me to do, I guess at this point, a brief run-through on what this BP is and kind of follow up on what you were saying, it does have that same left-to-right flow. I don't use the word information management. I use the word litigation readiness, which to me encompasses more than just managing information and focuses in on what lawyers do, and that is in-house counsel, and sometimes outside counsel helps a company with this to get ready to handle lawsuits when they come in the door, or if they're a regular litigant, to improve their readiness so that they can handle lawsuits from the very beginning, which is basically when they reasonably anticipate litigation, and get procedures, software, processes in place in order to be able to handle the eDiscovery parts of litigation in an efficient manner. And that is traditionally done by in-house counsel. I think that's the proper role for it. I think outside counsel should be educated on what inside counsel's efforts are, and sometimes some outside counsel can assist the corporation law department in this litigation readiness process. But that first stage is definitely something that I think is best handled internally, where a company is large enough to have a law department anyway. And the next step after that, they're all blue on purpose. I'm heralding back to the old days when we used to call litigation holds. We used to call them a litigation freeze. Remember those days, Mary?
I do. I do. Or a flash collection or something like that, yeah.
Yeah. We used to, in my old firm, we always used to call it, we have a freeze in effect. And so these are the three basic lawyer activities that are involved in litigation holds, in preservation, if you will. And again, I think most of these should be, are readily adaptable and can be performed by in-house counsel. I think it's appropriate, for instance, for in-house counsel, if there is one, to be sending out the hold notices as opposed to outside counsel. I mean, we almost never send out hold notices. If there's in-house counsel, it's being done by them. Or
yeah, I see sometimes the collaboration with outside counsel and inside counsel on a particular case. Many of our clients like to have a standard hold notice, but then their outside counsel takes a look at and makes sure that it meets the muster of the particular case.
Oh, absolutely. And what we do, I think a lot of firms nowadays, this is a law firm best practice, is we give our client, here's the form that we're using, and most clients don't have a form, or they take a look at ours and go, ooh, that's pretty good, we'll use that. Sometimes the client will say, we've got our own form, thank you very much. And if it's a repeat customer, we already know that. And then we just take a look at it, and make sure that it meets muster. And then all forms have blanks in them, hold notices, and we make sure that the forms, we help in-house counsel make sure that it's properly detailed. I mean, I'm on the phone all the time with, do you think this is sufficient notice? Am I describing the lawsuit clearly enough? The boilerplate of what to look at and stuff doesn't change very much, although, we updated last year to add iPads and things like that to the list. But but on each case, you want to make sure that the hold notices also go out to the right people. And that's always, that is a lawyer decision, who are the key witnesses. And so we're collecting the best practices on hold notices and on the rest of the whole preservation activities, which we're going to talk about the case, the gross construction later on, that emphasizes the interviews, that you don't just send a hold notice, you actually talk to your key witnesses. That's critical.
Oh, there's a concept.
Yeah, and you do it for a number of reasons. And then a best practice is, at least in certain size cases, which for us are, most of our cases, we're going to reach a point, at least where litigation exists, where we're going to preserve by collection. Now, you don't always have to do that, but the truth is, certain basic collection, such as email, is not very expensive. doesn't really cost much to spit out a PST from out of an Outlook Exchange server. And there's no better way to preserve than to have that stuff in your hand.
Right, and that's something that most internal IT personnel can do using the standard tools of Exchange with Xmerge, and it doesn't modify the internal dates of the send and receive, and it's totally appropriate and very easy to do with one or 2 minutes of training. And how do you? Well, we'll get to that, I think, in the next slide, perhaps, about handling chain of custody concerns for collection, and where do you store the collection?
But would you mind going back? See if that go back button will work.
Alrighty.
Just for 1 second, because I want to finish and I'll be very brief, but I want to point out about this dividing line between outside counsel and in-house counsel. Certainly. Usually cooperation is where you've got to have outside counsel, because there I'm talking about what the Sedona Conference calls the dialogues, setting up a dialogue with opposing counsel and with the judges. And this is not something, obviously you've hired a lawyer, you're going to use your lawyer to talk to opposing counsel, you're not going to talk to them yourself, and you're going to try and save yourself money and make this process more efficient by engaging outside the opposing counsel and trying to fine-tune what it is you're producing, what you're searching for. And then if opposing counsel doesn't cooperate and doesn't reciprocate, then you engage the other important party here, and that is the judge. And you go to a judge early and often if you have to, in order to scale and make your discovery proportionate. And that is the key best practice of all, and it's the key of cooperation, and that is proportionality. So this is something that we're collecting the best practices in this area, and I want to emphasize how important that is to practicing law in the 21st century, is to know how to cooperate and to know when and how to go to the court, and go to the court early, not at the end of the production when it's too late. I wanted to make that important point. And then just real briefly, the green buttons are equivalent of review done by lawyers. Culling is not automated culling. It's legal judgment culling, such as what are the dates where evidence is relevant? Who are the custodians you have to look at in phase one? What are the documents that you're going to begin to look at to start your production? CAR does not stand for automobiles. It stands for computer-assisted review. What is the latest review? Machine learning. And then protections has to do with the final labeling and removal of privilege, labeling and redacting of confidentiality, which is to me so important and is a lawyer-only kind of step, leading then to productions, which in best practices to do it in phases. And then finally, and this is always on the mind of lawyers, the evidence. Will it get into evidence? What kind of objections might you make? And how important is this evidence? So that's in a nutshell the whole collection of lawyers' work in the world of eDiscovery. So now, if you go on to the next slide, I'll let you take over here.
Well, I notice you put cooperation before you start doing culling and computer-assisted review.
Yeah, certainly do. I mean, the cooperation is where, like I say, you need to rely heavily on your trusted attorney that represents you in the case to represent your interests, and you have to do that and talk to opposing counsel before you begin your review work. Otherwise, you're at very high risk of the dreaded redo.
So, Ralph, how is your model being received?
Well, very positively, and you know, it's just, like you said, it's just started out, and I'm soliciting input from attorneys around the country. Ultimately, and this is one of the first times I've revealed this, I'm going to be appointing editors for each of these 10 steps that will kind of be in charge of it, of acting as a gatekeeper as we receive input from other lawyers. You know, how about this, how about that? They will act as quality control, and I'll just sort of eventually step back. But I've done the first work myself, you know, put literally hundreds of hours into this in my, quote, spare time to collect these best practices and kind of, these are not, by the way, just me dreaming it up. I would say 80, 90% of it is from other bar groups, from judges, from other lawyers. It's an amalgamation and a collection, and it will continue in that manner, but hopefully we'll get more and more people serving as kind of an editorial role. And I think we're all interested in knowing, you know, what is the best practice, understanding that the primary best practice is always proportionality. And so what's the best practice for a $100,000 case is going to be far different than a $100 million case. And it's very important to understand those distinctions.
Exactly. Well, proportionality being the best practice, I think that that is something that has been popularized and socialized over the last couple of years. Are you seeing the judges are more accepting of a proportionality argument if you need to go there?
We are having tremendous success with arguing proportionality, not only on the judge level when it gets there, but also with the opposing counsel level. We show them the cases, we tell them this is the way it is, and it's nothing new, really. The word itself is being popularized as new, but it's really an implementation of Rule 26B2C. It used to be, the argument was undue burden, and now it's the same argument. So there's plenty of authority, and there's a lot of recent authority that's come out, and it's just good common sense. You know, you should not spend more on discovery than the case is worth. There's a lot of arguments about what a case is worth, but that's the kind of thing it's good for a judge to hear, and judges have to go through these mental gymnastics all the time anyway when they discount what the plaintiff says or what the defense says, and they come up with, you know, what they think is a reasonable burden on a party to respond to discovery.
And so do you find cooperation in the first steps around hold notices and the preservation, or are you making a distinction between the sort of the flash collection to preserve and then further cooperation for preservation?
Well, cooperation, I mean, once you have an opposing counsel, it's good to include eDiscovery in your agenda of items to discuss. You know, there's the KPMG case. There was a lot of argument about what should be preserved or not, and you know, ultimately they had to take that to the court, and the court ended up ruling tough ruling against the defense, and the court mainly said, hey, we didn't see any cooperation going on. You were issuing take it or leave it fiats, and that's not how cooperation works. So, so no, I think cooperation in the right case does involve the preservation steps. Now, in your run-of-the-mill employment case, it's not necessary to do unless you've come across some unusual situation, because I personally think there are a lot of well-defined rules already out there about what should and should not be preserved. For instance, you know, tapes, there's no reason to preserve a backup tape. There's a million cases on that, unless it's the only place that the information resides. And this then becomes a lawyer technology analysis of it. And so, you know, one of the things that we do is if we get a demand letter on preservation from opposing counsel, and free advice to everybody, whatever you do, don't just ignore them. You must respond, and you must say, we will do what is reasonable, what is required of us, and by the way, it doesn't include save all of our backup tapes like you insisted, and your party also needs to be preserving. Little known fact, the plaintiff's duty to preserve is always going to precede in time the defendant's duty.
Isn't that something that is ignored at the plaintiff's peril over and over and over again?
Absolutely. And so, you know, at Jackson Lewis, we're taking the initiative, and we're making sure both sides preserve. And you know what? Our clients have their act together a lot better than most plaintiffs. And so eDiscovery is not something to be feared anymore. eDiscovery is an important tool to get at the truth.
So, Ralph, some of the best practices here around written hold notices around notifying the custodians and then notifying IT to stop auto deletion. How long do you go you do the proportionality so that they don't have to stop auto-deletion of everything?
Well, there is no set answer. I mean, if I had my way, it would all be done immediately because I personally think it's the most important thing in the world, but I have a myopic view, I admit. But the truth is, it's not hard to turn off the auto-deletion features. Or if it is, you have failed miserably in your litigation preparedness and litigation readiness. You should have your IT department lined up to, boom, at a email notice, send them the list of custodians, stop it. And follow up on that. They stop if someone's on a hold list and they leave the company, which happens in most cases with a lot of custodians, somebody's bound to go. Whatever you do, don't wipe their old desktop or laptop unless you've already made a copy of it and preserved it. So that's part of the IT notice. But you shouldn't just notify the custodian. Best practice is also notify your IT department and do it in writing so they have a clear record of what they're supposed to do and when they're supposed to do it. And make sure IT understands the sense of urgency that the law department should have by reading all these sanction cases.
Yeah, the termination and offboarding procedure is something that many companies are updating right now. I'm sure you've been assisting your clients in developing policies and procedures around that.
Yeah, I mean, just read Judge Shinlin's pension committee. She has 5 things that she says are gross negligence. And one of the 5 is failing to turn off auto-delete. Another one is failing to preserve information of employees once they leave. And the reason is these are 2 easy mistakes to make if you don't have a good process in place. And, you know, she sees them all the time. And so that's something that everybody must include as a best practice. And as well as actually talking to custodians, you know, things like, here's the list of people that are on hold. Sometimes you will tell them that if it's not too big and it's okay to disclose it. Is there anybody on here that you think we missed that would have information relevant to this dispute? Oftentimes the custodian will say, wait a minute, I don't see Joe Schmo on the list here. Joe really, he knew a lot. Or, you know, you've got Mary Ann on here and she had no involvement whatsoever. So it's really good to talk to custodians to help make sure that you've sent it to the right people and to make sure that they understand what's going on and that they understand what they're supposed to do or not do.
So often in the interview, you suggest as a best practice using a checklist?
Yeah, and we're developing checklists now. You know, surgeons have a checklist for brain surgery. And so why can't we lawyers have a checklist? I mean, I know this isn't brain surgery, and I've done it so many times, but I still like to have a checklist in case I forget something. And it's not long. I can do an interview of a custodian if they're not a pack rat like you and me, Mary. You know, I'm done in 15 minutes. If I run into somebody like you, oh my gosh, it's an hour and a half. Because I got to find out where do you have your information stored? You have how many computers? And, you know, basically we're trying to find where the evidence is and, you know, what we can do to get it. You've got a Facebook account? Yeah. Did you ever talk about work matters? Yes. Did you ever talk about this work matter? Yes. Okay, we're going to have to worry about collection. You know, that's basically what it's all about. Where is the evidence? Where does it go? Plus, there's some questions you ought to throw in there to make your search, your keyword searching later on also better, such as, what acronyms do you use? Is there any nicknames? You know, things like that. What's the language? You've got to tune yourself into the custodian so that you can know what's relevant. And, you know, in small cases, it's okay to let that custodian collect, but I mean small cases. Most of the time, we're going to avoid self-collection. And so the custodian, you know, my ideal thing is I like to interview a custodian if it's important right in their office and have them show me. So here's where it is. Here's the drives that you use. Here's the network stuff. So I'll know exactly what's going on. But you can learn a lot about evidence by talking to the people who actually create the evidence. And so, yeah, interviews are definitely a best practice, and so is circumventing the custodian and not having that custodian make the collection themselves, but actually for you to make bulk collection. Have IT departments do it. Most IT departments can handle that without a problem. If they can't, if an IT can't do a collection, then you can bring in a vendor to help them collect. But You know, that's not a law firm role either to actually do collection. That's a non-legal service.
No, we actually have software that once it's set up goes to the sources of data based on what the attorneys want collected, and we use a questionnaire if they want it to identify those sources and be able to point to them. Some of our clients, Ralph, are finding it difficult to get the IT resources in an era where many of the IT functions are being outsourced to the cloud or other third parties. And as part of litigation readiness, of course, you would help your clients have a rider in their third-party contract for immediate action on preservation activities or collection activities. But if a client hasn't been through that before, they generally find it tough to negotiate those things and get things done quickly.
Yeah, absolutely. And really what I'm talking about, too, is avoidance of the being criticized later on for having the fox guard the hen house, having a person accused of wrongdoing be the person who decides, oh, this is relevant, this isn't, because there's almost an irresistible temptation to not collect certain emails that you wish you hadn't written, and that can come back later on and can destroy your whole case. So there's that, plus you know, the custodians themselves are not, unless they're a lawyer, and even sometimes if they are, they don't understand necessarily the scope of relevance or the scope of responsivity to production requests. So they're not in a position to make a determination on what should be reviewed for production. This is, again, a lawyer task. And in small cases, still, we will delegate to custodians, but as you move up the scale of proportionality, it's just too risky, and there's too many bad cases out there where it's gone wrong to just let the witnesses decide what they think is relevant.
I agree. The idea of moving things into a folder, or especially moving it across media so that you change the dates when you put it in the folder, you forward the email. Those are just things that shouldn't be done. And yeah, our experience is that the in-house counsel makes the determination and directs the outside counsel in consultation with the outside counsel. Or sometimes the outside counsel is working directly with the IT department under the auspices of the general counsel, so that the IT department knows that they're supposed to give up what can be very, very confidential information.
Yeah, and I think I mentioned before that my firm has gotten away from even touching electronic evidence at all directly. I would just as soon not have my law firm or my attorneys in the chain of custody and set themselves up for evidentiary issues. I just wanted to go directly to the expert vendors and go from client IT to vendor IT and not give my attorney any opportunity to forget they have things or to not forward a laptop onto the vendor, for instance, like we're going to see in a case in a moment. So, yeah, we try and stay out of it and let the client handle that.
Yeah, flashing on the screen here is just a legal hold sample questionnaire, and I'll skip by that. I think we've just talked through this section.
Yeah, I think we have. I mean, in fact, we're getting right to this great case. Yeah, this is a great case.
Yeah, when I told you about it earlier, Ralph, I said that it has echoes of Swafford, one of your favorite cases. Mm-hmm. But both inside counsel and outside counsel were jointly and severally sanctioned for behavior in this case, and part of it was because the inside or the client, the corporation, tried to do things themselves and waited until 5 months to engage an outside provider. And what the court said was that 1 month was okay, but 5 months was not. Of course, this is the District of Maryland, and they are leading edge in eDiscovery. I thought that was interesting, that it's okay to try yourself for a while, but if you don't, if you don't succeed, you need to quickly find somebody to help you, whether it's outside counsel's resources or your own resources. And then the other thing is that they didn't get to the email quickly, and the court said that email, it was almost like incredulous, because email is so important in a case. One of the other things in that case that I thought was important, and Ralph, you can weigh in on this, is that they had some deposition misbehavior. So that's not eDiscovery, but it's an indicator of cooperation and respect for the other side, respect for the for the process, and your standing as a legal professional. That they abused the deposition process by canceling things abruptly and having the other side incur costs in that. And there was a lot of writing by the judge in the opinion about that, even though it was an eDiscovery. But because of that bad behavior in another aspect of trial practice, the eDiscovery sanctions were given. One other thing, I think, especially you, Ralph, the author of that wonderful law review article on date stamping, is that the judge did not like the idea that PDFs were produced and that it wasn't TIFF and date stamped.
Well,
do you have any thoughts on this case?
Yes, that worried me, but then you got to understand the details of it, and I would agree with the judge, actually, on this particular matter, because they number one, their first production was 20 pages. That was their production, and then later on they said, oh, gee, maybe we should look at email. And this is because the plaintiff's lawyer just told the plaintiff, here's the production request, you deal with it, and then didn't even check in with them. And so, finally when they woke up, then, by the way, this is where the plaintiff's counsel, for some reason, had personal possession of 5 laptops, and they forgot to give it to the plaintiff's IT department to search. So that's why I mentioned the laptops. That's right in there. But when they finally did make the production, like day before important depositions, they produced 112,106 pages of dead, flat, killed JPEGs, just images, which is the equivalent of paper. And they did it without any bait stamping on the paper. The defendants asked for TIFF and load. They asked for full metadata production, but the plaintiffs didn't give it to them. And so, yeah, when you produce paper, which is what they did here, it was just PDF, it was paper, you should bait stamp it. But more importantly, you shouldn't produce in a dead PDF just because that's all you know how to handle, particularly when you've been specifically requested, as you were here in this case, to produce in the full TIFF. And I love the plaintiff's lawyer's explanation. Well, gee, that's how they produce to us. They produce to us in PDF. Forgetting to tell the court, which the defense counsel then enjoyed telling, that the only reason they produced in PDF is because their first production to them in TIFF and load, the plaintiff's counsel said, gee, I can't handle this. I don't have any review software. Would you please produce it to me in PDF form so I can print it out and review it? And trust me,
good deed goes unpunished, so they reproduced it in a different format, huh?
Yeah, but none of this worked with the court. I mean, this is one of Judge Grimm's proteges up there, and it won't work with any judge. I don't care where you are. This kind of shenanigans by plaintiff's counsel will never be tolerated, and that's what you have here. You have, I believe, the first 26G sanction opinion that I've ever read, following up on Judge Grimm's Mancia suggestion that counsel ought to be citing to and referring to 26G that has a mandatory award of sanctions, and that's exactly what happened here for a very sloppy production made by plaintiff's counsel, who simply delegated the whole thing to his client, and the court pointed out, you are not allowed to delegate the whole thing to the client. Rule 26G, which has to be signed by the attorney of record, certifies to the court that you have made a reasonable effort, which they didn't do here, and that's why they imposed sanctions, monetary sanctions, against the client, to be sure, but also against the lawyers, not only the senior counsel of record who did the botch job, but I might point out also the poor young associate also got sanctioned, And in a footnote, the magistrate said, I would have sanctioned the law firm itself, but I didn't think I had the authority, so I had to sanction partner and associate who actually signed it because that's what the rule required. So this is, I think, an important lesson in Branhaven, is that outside counsel do have a duty. They do have a responsibility. If you want to do everything yourself inside counsel, then you need to appear of record, because only an attorney of record can sign Rule 26G, which is the Rule 11 of discovery.
Right, and it's not requiring perfection, but it is requiring a reasonable inquiry.
That's right, reasonable efforts, and here by the attorney, and you can't just hand it off to in-house counsel. They may be great, but you still have to know what's going on and be satisfied as an officer of the court that it's reasonable efforts. You can't just take the 20 documents they were handed to begin with and make a production and then go, oopsie, you didn't look for any email.
Right, and this also has echoes of the Qualcomm case, I think, as well. So we've got a little bit of time left. Would you like to talk a bit about the Rambus case, or should we save that for another webinar?
Well, look at Rambus as litigation readiness. Do not throw a pizza party for the teams that destroy the most outdated documents. You got to be careful when you get clean house, but you must clean house. But let's move on to the other cases. They're a little more interesting. I know we don't have a full time here, so go ahead.
Okay.
Yeah, because I want to talk about, this ties up, we spent a lot of time talking about the questionnaire. And, this is the wake-up call by Judge Peck, which is still hasn't been heard by most of the attorneys around the country, because, I see this all over the place. Even New York lawyers still seem to be unaware of the fact that you don't just search by using keywords that you guess up, that you figure, well, I think these would be the most important keywords to use. Number one, as Judge Peck has pointed out, keyword search itself is extremely limited, and it only gets a small part of the relevant documents. But when you just are guessing keywords, which I call like playing the children's card game of Go Fish, if that's what you do, you get a terrible result, and it doesn't work at all. So you need to investigate, research your keywords, and part of that research is to talk to the people that created these emails. Find out, what they think would be good words to use. Talk to them about their language. Be sure you have a list of acronyms used by this corporation. Be sure that you are really doing your due diligence, as opposed to the way it's still being done by most attorneys, which is not a best practice, and that is just guessing up keywords. I would say that is the quickest way to make a mistake, is to just think that you know enough to be able to guess what the right keywords are.
So, Ralph, you would deem it a best practice, I would assume, to do sampling.
Yeah, all kinds of quality control, testing, not to mention cooperation with the other side. Listen to their keywords. I mean, if you've got a good vendor and you're set up properly, you can test a keyword in a minute, maybe 2 minutes. You run it, you do the test, boom. It just came back with half your collection had that keyword. It's a no good keyword. So test it out, use quality controls and quality assurance. Know the difference between the two. There's a lot being written on this now, and so, I would point you to some of my writings on the subject on predictive coding. In big cases, it is not a best practice to use keyword alone at all. You must use machine training in any significant size case if you want to do it right. Machine training that is supplemented by keywords, what I call multimodal. And so we go into the best practices of review, of computer-assisted review, in some detail at my site here, edbp.com. So if you want to see what other attorneys are saying, this is a good place to check out the best practices for how to do search and review.
Very good. And we're coming up on the close. I'm going to put a slide up that has the citations to the cases and rules we've been discussing.
Yeah, I guess as a closing remark, I would just urge attorneys to take a look at the EDBP site. If you have a best practice that's not included there you would like for us to consider, just send an email or post a public comment if you want to make it visible to everyone. I accept all comments, or you can email it to me and we'll consider it. This is what they call a wiki process of group intelligence. No one lawyer knows it all, so I would welcome your suggestions. Also welcome any objections. You don't think something's the best practice, let me know, and we will give it due consideration. So, what we're trying to do is elicit a group input on this, and so I hope you'll come by and check it out.
Now, I would encourage folks to go to edbp.com as well as the eDiscovery team blog that Ralph is the prolific author of, because I've been reading your what did you call it? You call it a restatement, I think.
Well, yeah, I wrote a story and it ended up being 9 parts, and that's so cumbersome. So I just put it all together in one place so you could find my semi-fantasies about a search project in the future, and really
an imaginary search project in the future.
Right, and so that way I can't talk about the search projects I'm doing for clients, so I created in fiction. Plus, I'm trying to figure out ways to make eDiscovery spicy and interesting and fun to learn about. So I came up with this idea of putting it in a science fiction context to make it a little more interesting to teach this stuff.
Well, I want to thank you, Ralph, for helping teach our clients and the people that we're reaching through this webcast, and then also to make note of ITLEX, which is another one of your projects in addition to the eDiscovery team training that you maintain, where you are introducing not only to your students that you teach in a more traditional law school type of class, but you've gone national and international for current law students. So do you want to give the website for ITLEX and the dates of that conference? That's another good conference down in Florida.
Yes, it's it-lex.org, O-R-G, or .com also will get you there. And this is actually a project of my son, Adam Losey. So there's the next generation of Loseys coming, so we'll be here for a while. And Adam is focusing in on younger lawyers and on law students. And, I told him years ago, you ought to look into eDiscovery, not because it's something that I do, but because I think it's a tremendous opportunity for a young lawyer. And for once, Adam took my advice, and he's been thanking me ever since. And because it is a terrific opportunity. He's an associate at Foley that has a lot of responsibility now in eDiscovery, which has nothing to do with reviews. I mean, eDiscovery for lawyers, it goes way beyond just reading email, although that may be part of it. And so I urge all young people to check this out or tell friends that are in law school. They have a writing competition with cash awards for law students. And then October, I think it's 15th and 16th in Orlando, we have a 2-day event where the winners of the writing contest will present along with many notable judges who have already agreed to attend, and I'll be speaking there and a number of other people, and will be, something to make sure that the younger generation, who I think is much more tech savvy to begin with than people my age, are able to improve on eDiscovery, and the best practices in 5 years should be significantly better and more efficient and more effective than what we got now.
Well, I want to thank you again, Ralph, and I hope this is the first in many conversations that we have. And I'll turn it back to you, Alex. And Alex, thanks for hosting us.
Thanks, Mary. I want to thank today's speakers, Ralph Losey, partner, National eDiscovery Counsel for Jackson Lewis, and Mary Mack, Enterprise Technology Counsel for ZyLAB, for taking the time to join us today. And I would like to thank our sponsor for today, ZyLAB, for making this event possible. And as always, thank you, the audience, for taking time to join us.